Mrs. Jackson relays how Mr. Jackson and his children were making plans to enter the filmmaking industry and to pursue that together as a family project. Mrs. Jackson relays how she was personally offended, as was the rest of the family, when on the one-year anniversary of Michael Jackson's death, Dr. Murray arranged for a camera crew or photographer to accompany him to Michael Jackson's cemetery to be photographed. Mrs. Jackson indicates that the defendant violated her son's trust, failed her son, and failed her family. And Mrs. Jackson asks that the defendant receive the maximum sentence allowed under the law. Your Honor, the people join Mrs. Jackson in asking for the maximum sentence. This case, based on the defendant's own behavior, the defendant's own statements, warrants the maximum sentence, that sentence being 4 years in state prison. That is the just sentence, and that is the sentence we ask this court to impose, along with the requested restitution as the court deems appropriate. Thank you, Your Honor.
Mr. Walgren, thank you. The people have asked repeatedly for a maximum sentence of 4 years in state prison. Pursuant to the provisions of Penal Code Section 1170, Subdivision H, the Realignment Act, does the court have the authority under that provision of state law actually to send Dr. Murray to state prison, if I accept your argument?
He would not be housed in state prison.
Why is that?
Because of the very law the court's cited, because of the new statute. He would be housed either locally in a county jail or by other means that the sheriff deemed appropriate.
Does the court have any discretion in that sense?
No, Your Honor.
Mr. Walgren, you have submitted an Exhibit B, which is a letter from Mr. Howard Weitzman on behalf of the estate, wherein Mr. Weitzman lists certain expenses as memorial service, funeral, and associated expenditures in the approximate amount of $1,821,871.65. Is there any itemization of those expenses?
Not at this time, Your Honor, and it's a very reasonable and fair question. I will explain to Your Honor that obviously these finances are an extremely complicated manner due to the date for sentencing that was set. The people diligently and immediately began getting into contact with the appropriate representatives to obtain the appropriate restitution amounts. The court had asked for those amounts as is appropriate, and these are the amounts represented by the officer of the court, by the estate, by Howard Weitzman, that he represents are accurate for both the funeral and burial expenses as well as the tour. At this time, today, I do not have an itemization to give to the court.
Mr. Weitzman also indicates that the above information is a combination of monies actually spent and some very sophisticated projections on the anticipated revenue stream from a concert tour that had been sold out before Mr. Jackson's death. And the amount listed is the sum of $100 million in revenue. Would you believe that the court and the defense in this case are entitled to an itemization of the proposed sophisticated, anticipated revenue stream?
Yes, Your Honor.
Thank you. And let the record reflect that I have received, reviewed, and considered the people's submission in terms of the sentencing memorandum, as well as the exhibits attached there to Exhibit A, which is a CD, DVD, and Exhibit B, which is a letter from Mr. Weitzman. I have received, reviewed, and considered the defense sentencing memorandum, including the attachments thereto, a significant number of reference and character letters by friends and family and associates of Dr. Murray, and also I have received, reviewed, and considered the formal probation report in this case. At this time, on the part of the defense, does the defense wish to call anyone or otherwise make any statements? Mr. Chernoff?
I just want to make a brief statement, Judge.
Will the defense be calling anybody to speak?
No, Judge. We will not.
All right, may I indicate that, as I did before, that Dr. Murray has an absolute right to address the court at sentencing. It's his personal right, and if Dr. Murray wants to speak at sentencing, he certainly will be able to. Would you want to inquire of Dr. Murray whether he wishes to speak or not, Mr.
Spent
Chernow?
2 hours with him yesterday in the lockup to discuss this very issue. He doesn't want to speak, and I want to be brief.
You may. Thank you.
Judge, as you noted, we presented a 45-page sentencing memorandum. It was as complete as it could be. Attached to that were 35 letters of recommendation, reference, support from Dr. Murray's families, friends, patients. That was about as complete as we can get as well. We do not disagree with the prosecution that this is a tragedy, and what we lost with Michael Jackson and what his children lost certainly demands punishment. I do wonder, though, to what extent the court considers the entirety of a man's book of life as opposed to just one chapter. The 2 months that Dr. Murray was treating Michael Jackson, he did so regrettably. He shouldn't have done it. But when we talk about vulnerability, we're going to be honest about vulnerability. Michael Jackson was a drug seeker, and he sought it out from Dr. Murray, who was wrong in providing it. He sought it out from other doctors. He was a powerful, famous, wealthy individual with lawyers and security and staff and advisors. Maybe he was vulnerable. Maybe you agree with the prosecution. But what about before those 2 months? What about Dr. Murray's life before those 2 months? Before he was convinced or was decided based on suggestions or however you want to portray it to give Michael Jackson propofol? What about that life? I'm going to assume that His Honor believes that this is a case that demands incarceration. I make that assumption because of things that have been said and done. He was remanded after the verdict, and you said, and you believed at the time, that if you hadn't done that, he would be a danger to the community. 58-year-old cardiologist who now resides in a 5-foot by 8.5-foot cell. On Monday nights, he gets to see the stars because they take him up to the roof, shackled everywhere he goes. But he's not a danger to the community, I'll grant you that. And maybe you still feel that way. Maybe you feel that that's the kind of thing that should continue because he has to be in protective custody, and that's what will continue. But what about the rest of his life? What about before Michael Jackson asked for propofol? What about that? He spent 56 years, he's 56 years in June of 2009. 56 years. He never committed a crime. He was never ran afoul of the law. He had raised a family. I understand the tragedy with regard to Michael Jackson's children. I have children. We all have children. His children are here. has a kid in college, 2 more in high school. He's got a 2.5-year-old just now beginning to literally he can read. It's amazing, in Santa Monica. Does any of that matter at all, is the question that I have for the court. If we're going to start with 4 years that the prosecution believes is appropriate, does any of that matter when you make your determination? For 58 years, Dr. Murray, he was born in the West, in Grenada, illegitimate mother. Illegitimate. His mom, his dad, he didn't know his dad. They weren't just poor, they were literally dirt poor. At the age of 10 is when he got electricity in his community. But he took that impossible situation, that situation that would have crushed, or should, and continues to crush people in that situation. He made his way to the United States, a poor, unsupported black man from the Caribbean. He put himself through college, graduated in 3 years, magna cum laude, put himself through medical school, University of Arizona after that. Does any of that matter, that that's exactly what we want our neighbors and our citizens to aspire to do? And all of this was before he ever met Michael Jackson. Does any of that matter to the court at all? Maybe not. Maybe it's irrelevant. Maybe all that matters is what happened at the end. The court is aware of what Dr. Murray did. For 14 years, he prepared his life as a doctor. All he is a doctor. Now, that's gone. It's his fault. I'm not saying it's not, but it is gone. And if punishment's the point, if what you really are trying to determine is punishment as opposed to vengeance, should that be taken into consideration at all? Dr. Murray, whether he's a barista for the rest of his life, whether he's a greeter at Walmart, he's still going to be the man that killed Michael Jackson. That's really who he is now. He's not a doctor. That's who he is. Does any of that matter? You sat on the bench and you listened to 5 witnesses, 5 patients of his. He was only in private practice for 8 years. One of the witnesses you listened to was the prosecution's witness. They all told you that Dr. Murray had a positive, important impact on the quality of their life. 2 of them stated straight out they wouldn't be alive without him. 2 of them. Does any of that matter when you start at the top? Does any of that matter? Do you consider any of that? You heard from Ruby Mosley during the trial. You saw these letters that were provided. Dr. Murray, during these 8 years, despite trying to develop and build a practice, successful practice, gave back to communities that couldn't afford his services. He traveled to the Caribbean, training doctors on use of interventional cardiology, brought supplies to them that they couldn't afford. He opened up a clinic in Houston, Texas, my hometown, the poorest section of Houston, Texas. You didn't make any money at that. And you heard what Ruby Mosley said about that. Does any of that matter, is the question I have. Well, does any of that matter in your determination? That's the question I have. I think it should. I think it should matter what Dr. Murray has done in his life. I think it should matter. I think it should matter to everybody, frankly. I don't know about this realignment. I'm not, you and Mr. Walgren understand this better than I do. But I can tell you that putting him in a prison room there's a measure of vengeance that comes from that, and I understand that. But when the glow of vengeance has faded, he's still someone else's problem. And Dr. Murray can do things. Things on probation. He can do things for the community on probation that he could never do sitting in that little room. And I don't know what the point of punishment is, what you think it is. But I think it's what's best for the community. I think that's what needs to be looked at. And I don't see how prison would do that. All right, well, I've spoke longer than I thought I would, but you, Judge, we ask you to consider all that and what we've presented in our sentencing memorandum. Thank you.
Mr. Chernoff, thank you. Mr. Chernoff, I'd ask you the same questions I asked Mr. Walgren regarding the people's submission as to restitution. What do these requested restitution figures mean to you? What do you think I should do about this suggestion?
The figure is so high, it's hard to really to know what to tell you about that. I can tell you that Dr. Murray, if he has the ability to work, can certainly attempt to pay restitution, but he'll never be able to pay $100 million. That's not even, that's so far ahead of any possibility that there's no way to address that.
Mr. Gorgian has just provided something, Mr. Chernoff. I'll give you a moment.
We're just not ready. We need things. We need receipts. We need to look at the information that Mr. Weitzman has predicted to know about the amounts, but we are not ready to address that.
Right. Is it otherwise submitted, Mr. Chernoff?
It is.
Mr. Walgren?
Yes, Your Honor.
Thank you. One of the most difficult aspects of the job of judging is to impose an appropriate, just, and fair sentence. It's never an easy or fun responsibility. It's even more complicated when a judge is confronted with discretionary choices. In many of our cases, the terms are set in stone and the judge has no discretion. But when a judge is called upon to exercise discretion, it's a very significant responsibility. And that responsibility is compounded in a case such as this, where neither party is saying that Dr. Murray acted intentionally in being responsible for the death of the decedent, Michael Jackson. Even the people just acknowledged that Dr. Murray did not intend for Mr. Jackson to die. So the court is called upon to utilize its sense of fairness and decency, as well as various factors it has gained over the years of its experience, in fashioning what it believes is an appropriate sentence in this case. There are those who feel that Dr. Murray is a saint. There are those who feel Dr. Murray is the devil. He's neither. He's a human being. He stands convicted of the death of another human being. He's a human being. He stands convicted.
That is the appropriate standard. The standard of criminal or gross negligence, and the fact that a jury of 12 people from remarkably different backgrounds and life experiences concluded unanimously and beyond a reasonable doubt that Dr. Murray had, with criminal negligence, caused the death of Michael Jackson. It's important to emphasize the standard of criminal negligence found by this jury beyond a reasonable doubt, because some may feel this was a medical malpractice case. It wasn't. It was and is a criminal homicide case. And this jury found beyond a reasonable doubt that the defendant, with criminal negligence, caused the death of Michael Jackson. And criminal negligence is defined as follows. Criminal negligence involves more than ordinary carelessness, inattention, or mistake in judgment. A person acts or fails to perform a legal duty with criminal negligence when, 1, he or she acts or fails to perform a legal duty in a reckless way that creates a high risk of death or great bodily injury. And 2, a reasonable person would have known that acting or failing to perform a legal duty in that way would create such a risk. A person acts with criminal negligence when the way he or she acts is so different from the way an ordinarily careful person would act in the same situation that his or her act amounts to disregard for human life or indifference to the consequences of that act. It's important to remember and focus on those terms and not to treat them cavalierly, as some might, by saying, oh, well, it just happened. And, oh, well, if it weren't for Dr. Murray, someone else may have been involved. I categorically disassociate myself from those types of statements. This is not a question about what might have happened or what if someone else had been involved, if not for Dr. Murray. That is an insult to the medical profession. The fact is that Michael Jackson died because of the actions of and the failures to perform legal duties on the part of Dr. Murray, not some other medical doctor, and also not exclusively because of Michael Jackson. I accept Mr. Chernoff's invitation to read the whole book, and I have. I've been impressed by the submissions from family and friends and associates of Dr. Murray. It is a book of Dr. Murray's life, but I've also read the book of Michael Jackson's life, not isolated chapters from either. Regrettably, as far as Dr. Murray is concerned, the most significant chapter as it relates to this case is the chapter involving the treatment or lack of treatment of Michael Jackson. And Michael Jackson died not because of an isolated, one-off occurrence or incident. He died because of a totality of circumstances which are directly attributable to Dr. Murray. Not some mistake or some accident in the early morning hours of June 25th, 2009, but because of a series of decisions that Dr. Murray made which jeopardized his patient, which violated his obligations to his patient and the essence of his Hippocratic oath. Those violations overcome the other aspects of Dr. Murray's treatment of other patients and the good deeds he may have done before that time. Dr. Murray created a set of circumstances and became involved in a cycle of horrible medicine. The practice of propofol for medicine madness, which violated his sworn obligation for money, fame, prestige, and whatever else may have occurred. So I don't look to one isolated incident in terms of the misdeeds of Dr. Murray or the deeds of Dr. Murray. But insofar as this case is concerned, Dr. Murray engaged in a recurring, continuous pattern of deceit, of lies, and regrettably, that pattern was to assist Dr. Murray. It is almost inconceivable that Dr. Murray would have persisted in this pattern over such an extensive period of time. The lies, the deceit began and continued, as we heard for 6 weeks' worth of testimony, to build up an absolutely astounding set of circumstances. The lies from the inception of his medical relationship at the Holmby Hills residence in terms of ordering propofol in staggering quantities, unprecedented quantities. The lies to the pharmacy and to the pharmacist, the sophisticated, intentional deception in that regard, the lies and repeated deception to those associated with Mr. Jackson, whether it be members of the staff and also members of the production team, AEG, and Mr. Jackson's personal and professional associates. The continuing series of lies to Michael Jackson's security and staff personnel at a critical point in time. The unconscionable lies to healthcare providers, lifesavers, paramedics, and medical personnel at UCLA, which were not designed to help his patient, quite the contrary, which were designed to deceive and give Dr. Murray a way out. The efforts on the part of Dr. Murray to subvert the process by attempting to destroy evidence. Subsequent efforts to cover up by distortions and lies to law enforcement. If one looks to the crime of involuntary manslaughter in a vacuum, one can say this may be something that went terribly wrong, and it's tragic.
But it's so critically important not to have a superficial gut reaction to what happened in this case, but to look at the totality of circumstances in terms of the long-standing failure of character on the part of Dr. Murray to serve his patient. And when one does that, one can't help but be offended by the circumstances in this case. Of everything I heard and saw during the course of the trial, one aspect of the evidence stands out the most, and that is the surreptitious recording of Michael Jackson by his trusted doctor. And I have repeatedly asked myself, why did this happen, and for what reason? And I can speculate and surmise that there might have been some justifiable reason, some benefit to Michael Jackson. That would be an entirely unreasonable conclusion. That tape recording was Dr. Murray's insurance policy. It was designed to record his patient surreptitiously at that patient's most vulnerable point. I can't even imagine that happening to any of us because of the horrific violation of trust. And I can't help but wonder that if there had been some conflict between Michael Jackson and Dr. Murray at a later point in time in their relationship, what value would be placed on that tape recording? If the choice were to release that tape recording to a media organization to be used against Michael Jackson. And regrettably, that failure of character was compounded by later actions on the part of Dr. Murray, each of which amounted to a betrayal of trust and confidence and a clear violation of the doctor-patient relationship and an undermining of the phenomenal